welcome everyone to today's webinar on IP procurement and protection with our special guest, the IP law firm Knobbe Martens. My name is Stephen Armstrong and I'm the president and co-founder of Maple Business Council. And it's my pleasure to welcome you to our event today. I'd first like to go over a few housekeeping details. Our phones will be muted for optimal audio for everyone. And we're recording today's event to be able to share it with those who could not join us today. We do invite you to ask questions for our expert panel of speakers. We'll be taking questions throughout their presentation, and to do so, simply enter your question using the Q&A text box, which appears usually at the bottom of your Zoom panel. So for those of you who are not familiar with Maple, we just celebrated our 5th anniversary promoting bilateral investment, trade, and entrepreneurship between Canada and the US last month. And it's a real pleasure to do this work. We have done about 75 events in this first 5 years throughout Southern California and across Canada. In addition to our networking receptions, we've led commercial delegations to Vancouver and Toronto. We have thought leadership platforms for our member organizations to share insights on doing business across the border, looking north and south, as well as curating news and content of interest to businesses looking to work in both regions. In June, we had another celebration in addition to our 5th anniversary, and that was expanding our presence beyond Southern California, where Robert, Kelle, and myself are based. To date, our focus in the US has been on LA, Orange County, Riverside, and San Diego counties as we look at bilateral opportunities with Canada. But we're excited to announce that we've launched a Maple New York chapter serving the tri-state region, led by the former president of Purolator International, John Costanzo. And so you'll be seeing more information about Maple New York coming from us in the coming weeks, including an inaugural event online next month. In terms of our membership, we set out Maple to be a cross-sector and cross-growth stage community of executives. And today we have close to 100 members, including leading Canadian and US brands. And these companies operate in 20 different sectors. So there's some wonderful, rich, diverse networking opportunities and learning opportunities by connecting with one another. Our Canadian members are based from British Columbia to New Brunswick in the Maritimes. And we're particularly grateful for the membership and support of our speakers today from Knobbe Martens. Knobbe Martens has been a charter member of Maple, and also Marko Zoretic, one of our speakers today, is a fellow co-founder and board member. So now I'd like to turn over the presentation to my co-founder and Maple chairman, Robert Kelle. Rob?
Oops, sorry about that. Messing up my little screen share here. Well, great. Thank you, Stephen. Sorry about that. So today we're honored to have an expert panel of IP attorneys who are going to provide an overview of IP procurement and protection spanning patents, trademarks, trade secrets, and copyrights. This is valuable information for both Canadian companies considering expansion and growth into the US, but also scaling US companies. So we think that they'll have a great deal to offer. Each of us as we look to understand IP patent protection better here in the US. So I'm going to start with Dan Altman. So Dan's a partner. He specializes in patent protection and related licensing issues for biotech, pharma, and chemical industries. Mr. Altman was an editor for the Berkeley Technology Law Journal. He completed an internship with the former chief judge of the U.S. District Court for the Central District of California, and an adjunct professor for 11 years at the University of San Diego School of Law, where he initiated a course entitled Biotechnology Law. Several of the articles and publications, including chapters in the treaties, patent protection for second medical use, and world international property rights and remedies. Marko, who has been with us with Maple since the beginning, as Stephen mentioned, as a board member, handles cases involving patent, trademark, and trade secret matters. He represented both plaintiffs and defendants in a variety of technology areas, including medical and consumer electronics devices, computer hardware, software systems, engines, irrigation, and personal navigation devices. He's a graduate of Osgoode Hall Law School in Toronto and McMaster University in Ontario from with a degree in electrical engineering. And then Vlad Teplitskiy is also a partner with Knobbe. He advises clients in the areas of strategic patent procurement, patent portfolio management, licensing, and related items. He frequently counsels clients in electronics, communications, semiconductors, computer, IT, medical devices, and healthcare industries. He represents clients in inter partes review proceedings at the U.S. Patent and Trademark Office, as well as in patent infringement cases in federal district courts. He has a bachelor's degree in computer science and engineering, a master's degree in electrical engineering at UCLA, and a law degree from Hastings Law School in San Francisco. So with that, I'm going to hand it over to Dan.
Well, thanks very much, Rob. So what we're going to try to do today is give you a general overview of IP protection in the United States, which is, of course, the country where we practice. I wanted to tell you a little bit about our firm before we got started. We're one of the largest firms in the United States that practices in intellectual property. And if you measure firms based on the number of attorneys registered with the US Patent and Trademark Office, we're the largest. So we're concentrated on the two coasts of the US. You'll see our 7 offices listed on this slide. Orange County remains our largest office and headquarters office, but the other offices are all rapidly growing, so we have a nice footprint throughout the United States. Our firm works really only in the area of intellectual property and related technology. And so you'll see on the slide, it says 95% of our attorneys hold technical degrees. And so we're a little different than most lawyers in that we have both a technical background and a law degree. So we like to think we're more interesting than other lawyers. You can meet us and decide that for yourself. So let's see the next slide. So this slide, you'll see it's got a lot of small print on it. And the idea here is not to ask you to read it all, but to give you an idea that intellectual property and the technology law areas in which we practice is really quite a broad area. It covers a lot of different types of law, a lot of different types of technology, and our firm is active in all of those different areas. So even though you might consider us a boutique, when the law press talks about our firm, they say, well, we're a boutique firm. That just means that we specialize in this particular area, but it's really quite a broad area, and our firm is diverse throughout that entire area. And the next slide. So one of those areas of diversity is that intellectual property comes in a lot of different flavors. And there are the 4 main ones listed here, and these are the 4 main types of intellectual property that we'll focus on today. But there are actually others. There are certain other types of intellectual property that we won't cover today because they're somewhat specialized, but it's still a very broad area, and each one of these areas is really quite distinct, has its own set of laws, and works in its own ways. And that's what we're going to try to get across today. So let's go on to the first slide, which is on patent protection. So a patent is something that gives the owner the right to exclude. And that's why I put up this no trespassing sign, because that's really what a patent is. It gives you the right to put up a no trespassing sign on what it is that you're able to obtain a patent on. So specifically in the US, it's making, using, selling, offering for sale, or importing the patent invention. So it allows you to stop others from doing any of those things. But somewhat confusingly, it doesn't really give you the right to do anything. What it does is give you the right to keep people out of those areas so that they can't copy what you're doing. So this is an area of a lot of confusion for people who don't encounter patent law very often. That patent law is the right to exclude, not the right to do something. And if you keep that in mind, you'll have a much better idea of what a patent is. So in the US, there are 3 types of patents. There's a utility patent, and that's the type of patent that you probably think of when you think of a patent. It covers really what the function of a product is. So you can claim just not only the product, but the method of using it, the method of making it, and different aspects of the product. And that's the main type of patent, but there's also something called a design patent. In a lot of countries outside the US, designs are covered outside of the patent system. But in the US, they're part of the patent system, or you can go back just a little bit. And that makes designs in the US a little bit more interesting than in other countries. There's also a plant patent. And this covers only asexually reproduced plants. So in other words, when you take a cutting of your house plant, that's an asexual mode of reproduction. And it only covers plants that can be reproduced that way. So now the next slide. So there have been 10 million US patents granted. And in fact, now the latest patents being granted are in the 10,700,000. And patent number 10 million was just about 2 years ago. So you can see that the pace of patent granting has increased. If there's 700,000 in 2 years and 10 million in the 200 years before that. But between 1790 and 2018, it took to get to 10 million, and we'll probably be at patent number 11 million next year. Next slide. So we included this slide just to give you an idea of the breadth of patents that have been granted. And sorry about the kennel sounds, but the patents really cover almost anything that you can think of. There are patents granted in the US. And the first one that's shown there is the Statue of Liberty. So you think of that as being emblematic of the US. And of course, there'd be a patent because patents are an important part of the US. And the reason why I included light bulb and airplane, those are really quite important because there were a number of competing claimants to be the inventors of those things. But the patents were granted to Thomas Edison, of course, and the Wright brothers, of course, for the airplane. And everyone credits those inventors as being the inventors of those inventions. And it's because they were able to secure a patent for their invention. And the public really gives a lot of weight to the grant of a patent. And so that's a side benefit of a patent, is the recognition that it provides. So the next slide. So I wanted to mention there's 3 very common mistakes that people who are interested in patent protection will make. And the first one is something that is very important, that there is a process called a provisional application in the US. And this is a really nice provision. It's been around about 20 years now, and 25 years indeed. And so it's become quite common when you are making an invention to put together a provisional application and then say, okay, now I've got this. It doesn't meet all the formalities, but I stuck my stake in the sand. Now I can do whatever I want. And unfortunately, if you don't have a well-drafted provisional patent application, then the provisional application is really going to be almost worthless. Because what the provisional application, even though it doesn't require formalities, it does still require a complete description of the invention you want to protect by patent. And so if it turns out that there's some little detail that's important to your invention that's not disclosed well in your provisional application, and that's what you end up claiming, then you're not going to get any benefit at all to your provisional application. So even though provisional applications can be done more quickly because they don't have as many formalities, not having a good provisional application is probably the biggest mistake that we see. Another mistake that we see that we're often required to clean up is that when any part of the invention is made in the US, the patent laws in the US require that either a first filing of that invention be made in the US or that something called a foreign filing license be obtained. And so this is fairly common in countries like Canada that are close to the United States and where they may have a lot of business connections between Canada and the US. And so it turns out part of the invention is made in the US. And if such an applicant files first in Canada and then files later in the US, what can happen is that the US patent, even if it's granted, if someone later discovers that it was partly made in the US patent is considered invalid. And so that's a very draconian punishment for a patentee to have their patent invalidated. And therefore, it's important to keep this in mind. There is a process for a retroactive foreign filing license, but the Patent Office has become very picky about those. And so we have to fight very hard to get those after the fact. So the third mistake that I'd like to tell all of our participants today about is not filing something called continuation applications. Continuation applications are something that you can file while your original patent application remains pending. And what you do is you file essentially a copy of the original application, but you go back and try to get more claims. So this is the claims is what determines the scope of your patent. And so very often in a first application, you have to fight really hard and the examiner digs in really hard and you end up with claims that are loaded up with limitations that might not exclude everybody that you want to exclude. Remember, the patent is the right to exclude. And so if you file a continuation application, you can then start creating a number of pickets to create a big picket fence and really create a strong patent portfolio. And we can't emphasize enough how important that is because really most of our domestic clients will file lots of continuation applications, get strong patent portfolios. And if they have to enforce or if they have to impress investors, this portfolio of continuation applications is extremely valuable. And for some reason, patent applicants outside the US tend not to take advantage of this. And they're really missing out on a lot of value by not doing that. So these are three important mistakes to be aware of. And if you're aware of them, even if you don't know how to solve them, you know to talk to your patent attorney so you don't make them, and you'll improve your position very well. So now I think we'll turn it over to Marko and talk about what happens once you have a patent and need to enforce them.
All right. Thank you, Dan. Thank you, everybody, for showing up today on these crazy times. So just let me touch quickly on patent enforcement. And so once you have a patent, what are you going to do about it? Dan has that no trespass sign, but if nobody's going to enforce that no trespass sign, it's pretty useless. So first, let me just talk about something basic. Dan mentioned the claims of the patent. And so if you want to determine if there's infringement of a patent, you're not looking at the words, all the like the lengthy description, although that does help you to define some meaning. You're looking at the back of the patent and you're looking at the claims. For example, if you had a claim that said a device for sitting comprising 4 legs and rubber stoppers under each leg. So if you made a chair, but you didn't put those rubber stoppers, you wouldn't be infringing. So the point is generally just for patent infringement, you look at the claims and you have to find each element. So say, for example, you have your patent and you think somebody's infringing. What are you going to do about it? So before litigation, what is usually done is a cease and desist letter. You can, of course, send a letter to that other side, say, I think you infringe, please stop. There's a whole spectrum of letters. That could be just as simple as that. I have a patent, please stop, don't do it anymore, and I'll go away, to a letter that is stop in 2 weeks, tell me all of your sales, and give me some money. Otherwise, I'll sue you. So you have the entire spectrum of letters. But so, for example, say you send your letter and they ignore you, and what do you do? So your last choice is, if you want to enforce your patent rights, is to go to court, and that's U.S. patent litigation. So a patent litigation in the United States is a federal matter, so you're in federal court. And just to, this is usually a question, is how much is it going to cost me? So it depends. It's very variable, because some cases will end quickly and some will go the distance. And so the first chart here shows some statistics, recent statistics on median cost. And this is through trial. And so generally, these are ballpark numbers, of course. So if it's around $1 million to stake, you can expect around $700,000 in litigation costs. And it goes up depending upon how much is at stake. Obviously, if there's more at stake, there's going to be more of a fight. And that's why these costs are going to go up. So why is it so costly? Well, the United States is very is litigious, and it's a long process. And probably the biggest factor as to why the costs in the United States are much larger than in Canada, for example, and probably anywhere else, is the fact discovery. There's very intensive fact discovery and extensive fact discovery in the United States. So what is discovery? Discovery is basically you're trying to find out information from the other side. So you can do it in a bunch of ways. We serve document requests, which means that they have to produce the documents we are requesting. We do interrogatories, which are basically questions, and they have to answer those questions. We do depositions, and depositions are probably the most annoying part to any defendant, or any party actually, where you have to sit there for up to 7 hours of questions and answers, and sometimes it's not very nice. We always try to be professional, but just how it is. We're asking questions for a long time, all day. So that discovery period, is long, and it's a lot of effort. Another part in patent cases that makes costs expensive is we have this claim construction process. I was mentioning the claims in the back of the patent, and there, even though you have words there, you have to, we have this process of construing them. What do words mean? You think maybe they mean what they mean, but sometimes it matters. What does some word really mean? And so the court will define those as a matter of law. And so there's a process that goes through that. There's briefing, there could be some discovery that takes place. And so it is also a lengthy and involved process. And then if you get to trial, it's a jury trial in the United States. Unless if there's no damages for some reason, it would be a bench trial typically. But a jury trial, that is very expensive. You have to prepare, in front of a jury, have all your witnesses ready, documents ready. It is a very intense effort. Literally, when I go to trial, I pretty much disappear from my family. I go to the hotel. I probably won't be seen for 3 weeks. We stay there. We have our war room, and it is just like war for us, and it's nonstop. It's 18, 19 hours a day of work and very little sleep. So it's very, that also means, of course, it's expensive. The average time to trial is about 2.5 years. That, of course, depends on where you are, what districts you are in the United States, and how complicated the case is. And because of this expense, you can imagine that a lot of cases do settle, depending upon how much is involved, risk. So 95% of the cases, more than that, settle before trial. So we don't even get to trial. We could settle at the letter stage or anywhere in between. So that's what happens. So let's go to the next slide, please. So this is a pretty detailed chart on the litigation process. I'll just touch quickly on the points. So basically, how do you start a lawsuit? You file a complaint in a federal court. But that really doesn't trigger the lawsuit. That lawsuit only starts where that defendant has anything to do anything is when it's served. It has to be served on the defendant for the lawsuit to actually begin. And what happens many times is the plaintiff will file that complaint and then send the letter to the other side, saying, look, I filed a complaint, let's try to resolve this. And if it doesn't work, then they'll ultimately serve it. And then here we go. The defendant answers the complaint. Pretty quickly, within a month or two, we have what we call a 26F conference, where the attorneys from our side, the other side, we meet, we set up a schedule, we propose a schedule to the court, we discuss settlement possibilities, and then we submit that to the court. Court pretty quickly has what they call this case management conference. That's the initial conference, and the court will then set the case schedule, basically end of certain periods in the case, deadlines, and the trial date. And then you're going to go through claim construction. One of the bigger aspects of patent litigation now is we have these things called infringement contentions and invalidity contentions. So at the beginning of the case, instead of asking the other side, hey, tell me why I infringe, like explain to me why I infringe, it's an obligation on the plaintiff to provide a really detailed description of why they allege that the other side infringes. And then probably around 2 months after that or so, the defense, if they want to argue your patent's invalid because of, there's something that was invented before, you don't have a right to this patent, for example, they have to provide invalidity contentions. And those are two very, very involved documents, very extensive, and a lot of work goes into that. So ultimately, you go through all your discovery period. There's this major moment in the case called summary judgment motion. And that is where you ask the court, listen, court, instead of going to a jury, nobody disputes these facts. These are the important facts. And this is the law. So if you applied those facts with the law to the law, there's no dispute here. I should win. And so you decide a judge, and we won't go to a jury. We won't have a trial. That usually happens at the end of every case, and sometimes it works, sometimes it doesn't, and sometimes it decides some of the issues. So if it doesn't work, you're going to go to a jury trial. A lot to talk about there. I won't go into those details. You have your verdict. Hopefully you win, and then most oftentimes it's appealed. So that's generally the process of patent litigation. And generally in federal court, this is the process minus claim construction and contentions. So if you go to the next slide, please. So this slide just generally shows the number of patents granted. Dan mentioned how it is increasing. So you can see there the number of patents granted is increasing in the red. The number of patent litigation filings has been decreasing in recent years. There's still a lot, but it has been decreasing. And probably the factor that is most important to this is that it's become easier to challenge the validity of patents. For example, a process we call inter partes review, where instead of litigating the validity of a patent, you actually go through the patent office and litigate that before the rest of the case happens. So it's kind of been dampering people if they have patents that are maybe they view as weak, not as strong. They will resist asserting them in the first place. Because it's a cost to that plaintiff to go through the IPR process. And there are some other reasons as well. Generally viewed that damages are harder to get in the case too. So that gets into the mix of, do I bring a lawsuit or not? So on the next slide, just to give you a sense of damages, this is of course very fact specific. It depends if you sell a lot of products at risk and some features very important, the damages are generally higher. But the median damage award has been around 6 million. And on the right side, you could see generally by technology area, the biopharmaceutical has had in general larger awards, obviously because probably big sales, and the same with medical devices. But this is of course very fact specific. It's going to depend on your case. Next slide.
So at this point, I want to just ask a couple of questions. So Dan, if the USPTO grants me a patent, how can I be infringing someone else's patent?
One thing that's very important to know about patents is that the validity of a patent and the infringement of a patent are completely separate issues, that they really essentially have nothing to do with each other. So what the Patent Office does is they evaluate whether you have the right to obtain a patent. In other words, do you have a valid claim to an invention? Whereas when someone accuses you of infringement, they're accusing you of infringing their claims. So even if their patent doesn't prevent you from getting a patent on your invention, it's quite possible that they have a patent that can stop you from using your invention that you just got a patent for. And this is a very difficult concept for most people who don't work in the patent area to really accept, because it seems so counterintuitive. But if you think of validity and infringement as completely separate, you will probably understand both better.
Thanks, Dan. A question around plants. So if plant patents only cover plants reproduced asexually, how do you protect plants grown from seeds?
Well, so for some reason, when the plant patent statute was developed, they decided to make it only cover plants that could be asexually reproduced. I think the reason for that is that it is always genetically identical when you reproduce a plant that way. But at some point, developers of plants like grains, like corn and wheat, they wanted to have protection for their strains of plants as well. And so a completely separate type of protection under the Department of Agriculture was developed called plant variety protection. So all varieties of plants can be protected as such. And it's also possible to get a utility patent on a plant if you have something that is inventive about the plant itself. So you can get something broader than just the strain that way.
Okay, okay. Another question I'll give this one to Marko. Can you give some examples of how extensive fact discovery can be during litigation?
Sure. Okay. So fact discovery, there's generally a limit of 10 depositions, but imagine 10 depositions of people in your company. So your CEO, marketing director, all your engineers. And so that's a lot of depositions, and you can ask pretty much anything. Anything's fair game, it seems. And so, that takes a lot of time away from running your business and being involved in litigation. I'm also, like production of documents, I mentioned the document requests. You can produce hundreds of thousands of pages of your documents and emails. Mind you, that doesn't go to the other side, like the other company doesn't get to see that. You have a protective order in the case so that only the other side's attorneys can see it, and they can't share that confidential information with the other side. But it's a process to gather hundreds of thousands of pages and sort through emails and provide those emails to the other side. And then there's always a dispute about discovery. You ask for something, the other side says, I gave it to you. And say, well, no, you didn't. Yes, I did. And so it's a dispute. How are you going to resolve that? And you go through a process of filing motions, and you file briefs, and you go to court, and you fight about it. So a lot of disputes really makes it, raises those costs.
And then I guess another question. So, you guys have technical degrees plus law degrees. And you mentioned that patent infringement cases that go to trial are often decided by jury. How does that come to be, when it's a really technical situation?
Yeah, that's interesting because, for example, I'll live with a case for 2 years, get really involved in the technology, become an expert, for example, like diesel engine combustion. You really become an expert in it because, for example, I'm taking the deposition of the other side's engineers. I have to know what I'm talking about. So we really get technically smart on these subjects, and we know it. And then when you go to trial, that's the way it is. Your jury is of your peers in that area. And so it could be, you can have a very complicated electrical engineering, whatever case, and the jury that's selected is going to be what's selected. And you can have somebody who is maybe just dropped out of high school and sells smartphones at the mall, hasn't had any technical education. So you have to deal with that. You have to present your case the best way you can to your jury that you have. And that makes you, that's some work to kind of, not necessarily dumb it down, but you have to be able to communicate it because the jury is going to decide it. And it does make that a little bit scary because you don't know what you're going to get. We try to guess, and we try, educated guesses about our jury and what they're like and what they don't like, but you never really know. So even though you're proud of knowing all your technical intricacies, when you get to that jury and you see that person really maybe doesn't care, you have to still present your case.
So I'll read the next question from Claire Waters here, and just, I'm not sure who wants to answer it, but I'll read the question. You guys decide. So could you talk through a couple of examples of what can happen when a company files a patent in Canada first and then in the USA versus the other way around? If you start the filing process in both companies at the same time, would you run into issues if the US filing process took longer?
Vlad, you indicated you would take this question?
Yes, I can. Yes, thank you. Typically, and I'm not sure if I'm answering this question right, Claire, and please let me know if I'm not answering exactly what you asked, but the typical process with filing would be to file in a home country first and then take advantage of the 12 months up to a year convention period to file in other foreign jurisdictions. And this certainly could put the patent applications on different tracks with respect to examination. And it is possible, and we do see this a lot for clients who file in US and internationally, that different patent offices can treat the patent claims differently and even sometimes apply different prior art or different publications against the claims, or sometimes apply the same publications differently under their national laws. So we would have to face whatever the Canadian Patent Office would decide to do with the claims separately from whatever the US Patent Office would decide to do with the claims. Fortunately, at least in my experience, the Canadian Patent Office typically looks to what the US Patent Office does, and in case the US Patent Office hopefully allows the claims, and the Canadian Patent Office would likely do so as well.
Okay, so I hope that answered your question, Claire. Let's go ahead and proceed on. And if we have any other questions, again, please post them in the Q&A and we'll come back to those questions.
Yes, thank you. Thank you, Rob. The next form of protection, which is important, is trade secret protection. And the reason why we decided to present it next is because trade secrets are often complementary to patent protection, in the sense that, and I will explain this as we go through the slides, that the clients often choose whether to file for a patent or just to keep this information secret. And the reason stems from the fact that the policy considerations underlining the two forms of protection are somewhat competing. We didn't cover this, but technically when an applicant files for a patent, the patent application has to disclose everything that relates to the invention, how it works, the best mode, all the details about that would enable and describe the claims, whereas the trade secret protection has a completely opposite policy consideration. It favors secrecy, actually, by the trade secret holder. So as long as the information remains and can stay secret, there is protection that's afforded to that type of information. Next slide, please. So in a nutshell, trade secret, as you can see here, has three has three elements. It applies to any information, and that can be very, very broad, and I will give some examples in the next slide, that derives economic value from being secret, and that is any basically competitive advantage to the trade secret holder that that information can provide. And probably the more important prong is that is subject to reasonable efforts to maintain secrecy. That's important. Trade secret information has to stay secret in order for the protection to come to light and to continue. And what does trade secret protection really afford to the trade secret owner? And that's the protection against misappropriation. And that would be, as you can see in the list, acquisition by improper means, so espionage, bribery, Tom Cruise, as you can see in the picture, dropping on cables and stealing information off of that computer. And so this is protection against the party who actually steals or takes the secret information, but there is also protection against the third party who acquires the information subject to trade secret from someone else with either knowledge that that information was improperly obtained or with good reason to believe that that information was improperly obtained. Next slide, please. There are some famous examples. Probably the most famous one is the formula of Coca-Cola, which has been around, I believe, since late 19th century. Coca-Cola executives decided to keep that formula a trade secret rather than file for patent protection. And it's a well-known trade secret that is heavily guarded. Allegedly, it's stored in a vault in Coca-Cola's headquarters in Atlanta, and well, very few people have access to that vault. That formula is, I didn't know this, but as part of preparing for this presentation, that information was stolen in early 2000s, and someone wanted to sell it to Pepsi, but to Pepsi's credit, they immediately informed Coca-Cola, and that person was arrested and actually put in jail for trying to for this type of industrial espionage. Next slide, please. So I touched upon this a little bit earlier, but there's complementary and competing interests between trade secret protection and patent protection. And this often happens with inventions or things that are potentially subject to protection by utility patent. We have clients who ask us, what should I do? Should I file for a patent application and try to obtain a patent, or should I keep this information secret? And there's a list of considerations here to think about and to consider. And the first one is the public disclosure of the patent system. The patent system provides protection for full disclosure. So if this is something that the company would rather not want to disclose, then that's a good indication for keeping it a trade secret. Duration is another consideration. While patent protection provides more robust coverage that is limited to 20 years from the first filing date, whereas trade secret for as long as that information meets the three prongs that I discussed before, and specifically the prong that the information still is maintained as a secret, that could last forever. As with Coca-Cola, we're approaching 140 year anniversary of Coca-Cola's formula being secret. Another important consideration is whether the information, this particular technical information, can be reverse engineered or independently developed. And these types of considerations defeat trade secret protection because they're not considered to be misappropriation. If someone could just reverse engineer the technical secret from buying the product or analyzing it from marketing literature, or they could just independently develop it, that's fine. And that immediately the trade secret protection would evaporate at that point. And another consideration is how easy is it to detect infringement, and I have these conversations with my clients often. For example, in case of a software invention or a software invention, let's say it's buried somewhere in the code, somewhere on the backend server, and it will be very difficult to know if someone has copied it, even if there is patent protection for it. And maybe that type of information is best kept as trade secret. And then, of course, the costs. Patent protection can be more expensive, of course, because it requires a formal process for preparation of patent application, paying the official fees to the patent office or patent offices, and then going into what we call prosecution, where we negotiate with the patent office about the scope of the claims and meeting the technical requirements that patent laws provide in order for the patent to issue. So these are considerations and these conversations we have very often with our clients.
Okay, I'll touch quickly on the enforcement of trade secrets. So what's the typical scenario of a trade secret case? Usually somebody leaves your company, goes somewhere else, and all of a sudden, in a quick amount of time, they've developed a product that you've been making. And so there's the belief that you, the first company, that hey, that person left, obviously took some knowledge that we kept a secret, and now they're using it, and now they're competing with us. So that's the typical scenario. And so what are you going to do about that? So next slide, please. So in California, we have the California Uniform Trade Secrets Act. That's a state law cause of action. And very recently in 2016, there was the federal cause of action for Defend Trade Secrets Act. So these are generally the same. They're substantively the same. So if there is some kind of action in California, what typically happens now is you go to federal court, you have a claim for your Trade Secret Act under the DTSA, and you just throw in the California Uniform Trade Secret Act as well. So the law is still settling on how these two interact. But generally they're the same, and they're going to give you this same result. The one major difference with the federal act is that there's this civil seizure in extraordinary circumstances. So a court in an ex parte application, that's basically an emergency application to the court. You run to the court, you file an emergency application saying, you have to get them to stop. Look at all this harm. If you don't stop them now, I'll be irreparably harmed. And so that's something that you can do under the DTSA. So next slide. So compared to patent litigation, trade secret litigation has become more expensive in recent years. Sometimes it's just a very valuable secret, and there's a lot to litigate. And the two real things that spend a lot of time litigating and raises the costs are, what are your trade secrets? You need to identify them with particularity, and it sounds easy, but it's not. Many times it's a very extensive process to actually identify what your trade secret is, and the other side won't agree that you're specific enough. So there's sometimes a lengthy dance of you actually identifying the trade secret. And then on the defense side, for it to be a trade secret, it's got to be a secret. So there's a lot of work to find something in the public domain to show that this is no secret. Look at all these patents or other publications, or people of skill knew about it, or we can easily figure this out. So there's a lot of work on the defense side to try to show that there's no secret at all. So those are kind of the two big buckets of costs. And of course, it's just like patent litigation, all of the discovery is the same. There's a lot of discovery. And it seems that discovery is a little bit more contentious because this seems to be a little bit more personal trade secret cases. So sometimes rationale of costs might be dwarfed by principles and emotions. I'm just guessing, but that's what it seems to be. These cases get a little bit more emotional. You're more tied to them. And so the timeline is the same generally as in a patent case. And so basically what you're trying to get are damages and an injunction. You want some money for the harm and you want them to stop. So that's just basically on the trade secret litigation.
Marko, this is Stephen. Question, you had shown the trend line for patent litigation kind of decreasing in recent years, although maybe high historically. Do you have any insights on the trade secret litigation volume these days?
Yeah, I don't know the volume like by numbers, but it seems to be increasing. I think people are choosing that route more often now. I think the DTSA has promoted that. You get to go to federal court. So yeah, the trend line for trade secret cases is certainly up.
Thank you. Question for Vlad. What measures can be taken to maintain secrecy of information for which trade secret protection is desired? Vlad, you may be on mute.
Thank you, sorry. As I was saying, label or designate information as confidential, whether it would be paper information, electronic information, limit access to people who need to know. So use keys, badges, keep the information segregated. Don't publish or distribute, obviously, information if you want to keep it secret, and also use appropriate agreements with confidentiality provisions when talking to third parties.
Great, thank you. All right, we don't have any other questions at this time, so we move on to the trademark section.
Yes, so now switching gears completely from things that relate to technology, we're going to get into things that relate to brand protection and a trademark. Next slide, please, Rob. And a trademark provides protection for words, symbols, and designs, and I'll show you some examples that identify or distinguish the source of products or services. And the protection that trademarks afford is protection against unauthorized use that is likely to cause confusion among consumers. So as I was saying, trademarks are, next slide please, Rob. Trademarks can protect a broad universe of logos, designs, as you can see here, many famous ones. Next slide. Words and phrases. Next slide please, Rob. Sounds, so you can see here, all of these are actually registered federal trademarks in the US. Darth Vader's breathing, the clock ticking for 60 minutes. So there's really a very, very large universe of subject matter that trademarks can protect. And the important point to remember for US at least is that while registration with the US Patent and Trademark Office in order to obtain trademark protection is not strictly necessary, there is something called what we call common law protection, which derives from first use of the mark. Registration does afford a slew of benefits which make it really very advisable to register the trademark. And these benefits include the nationwide priority to use the mark across the entire US, whereas relying on common law use, unregistered use, you would have to show first use in particular geographic area. Presumption of validity of the mark, ownership and exclusive right to use the mark across the entire country, the right to affix the R symbol for registration. And another important thing to remember is in both US and Canada, it's possible to file for trademark registration without actually using the mark in connection with selling goods or services. So say, for example, for a company that's not quite ready yet to go to market and is developing a product or developing a service, there is a way to protect the particular trademark by just filing an application with intent to use and then proving the use for the trademark at a later time. I'll turn over to Marko for trademark enforcement.
Okay, thank you, Vlad. Okay, so let's go to the next slide. So just one slide here on trademark enforcement. So trademark enforcement is very important. If you're not enforcing your trademark, you risk losing your trademarks. So there really is an obligation on a trademark holder to police their trademark rights, or they risk losing them. Because basically if other people are allowed to, if you allow other people to use your mark, well, it doesn't really become your mark then, and it's associated with other people, and so you lose your rights. So you need to enforce them. And so there's basically 3 mechanisms. A cease and desist letter, you write to the other side, tell them to stop using that mark. And sometimes you can reach an agreement where, okay, we won't use this mark, or we'll use the mark, but we'll only use it in this area. Sometimes, trade dress is involved, so it's like the look of a product. So maybe some color questions where you're going to limit colors. So there could be some, back and forth. But basically, you want to draw lines around other people and keep them away from your mark. The Trademark Trial and Appeal Board opposition proceedings, that is basically you're monitoring the filings in the Trademark Office to see what's being filed. And if you don't like some mark there, you think it's too close to yours, you can oppose it. And so there's opposition proceedings. It is like a mini litigation. There are depositions, but it's mostly on the papers, so to speak. There's a lot of writing. It's not as litigious. There's no jury trial. It's an administrative proceeding. So that's one way to keep marks from coming close to you. And then, of course, there's trademark litigation if there's trademark infringement. And generally, trademark infringement is not the focus. Is not on damages. Damages are generally very hard to assess in trademark cases. It's really that injunction. You just want them to stop. And so this is probably the most important point here for trademarks and for people to understand is that the test is the defendant used the mark without the consent of the plaintiff, of course, in a manner that is likely to cause confusion among ordinary consumers as to the source, sponsorship, affiliation, or approval of the goods. So likely to cause confusion as to the source or affiliation, etc. So let me just give you an example of that. So imagine people know that Starbucks sells coffee. And so you could say, well, I'll put the Starbucks mark on a chair. They don't sell chairs. Well, you know what? So what? Starbucks maybe doesn't sell chairs, but that mark is so strong that people are gonna likely be confused that your chair with a big Starbucks symbol on it was somehow sponsored by Starbucks. So that, that is infringement. So you keep in mind, it's the likelihood to cause confusion. That's the test, not necessarily the goods. We had a recent case that went to trial. It was Monster Energy. We represented Monster Energy. And people generally know Monster in the sporting worlds and associated with energy drinks. And the defendant there was someone who sold tools. And it didn't matter, the jury still found infringement because the Monster marks were so strong. They found a likelihood of confusion there. So it's not just your mark and on a different product. It's about that strength of the mark as well.
Marko, how sensitive is the issue of properly treating your trademark in copy and in communications to being potentially putting yourself at exposure for someone to say, well, you haven't employed the best practices in treating your trademark, therefore I'm making a claim, or I have an opportunity.
I'm not sure what you mean. So,
well, if a trademark holder is not maybe using the circle R correctly or using a trademark in a proper manner, is that a very sensitive issue or not?
It does come up sometimes, but usually it comes up because it's just a slip. Sometimes someone just puts an R just before it was really registered, and it's like, okay, my fault. There's trademark misuse, but those are like bad facts, but those really don't play out that much. You should, you can put a TM, if you're using something as a mark, you can put that TM on it right away. So no, it's important to use it the right way. You should, of course, talk, if you don't understand how to use your trademarks properly, talk to a trademark attorney about using it properly. Really, you want to do it right so that when you do have a dispute, these things aren't at issue.
Okay. Thank you. A question for Vlad. What is the duration of a trademark protection?
Hypothetically, it could be indefinite, as long as the mark identifies the source of goods and services, and it continues, and it doesn't become genericized. I didn't talk about it, but there's an example of aspirin that is a trademark in Canada, but is no longer a trademark in the US because it became generic designation of pain relievers in general. So long as that doesn't happen to the trademark, it could be indefinite, provided that some formalities are met with the Trademark Office, for example, paying fees every 10 years for renewals.
Thank you. I think we're at the top of the hour now, so in the interest of everyone's time, we're going to pass to the copyright section, and we'll just wrap up now with some remaining updates for you from Maple.
Give me a moment. Oh. There we are. Sorry about that. So thank you for joining this webinar. You know, we've moved, as many have, to a virtual model since, you know, we're all living under this pandemic and working from our homes, as you can imagine. So in April, we did a webinar on future-proofing technology. That was with BlackBerry, the Canadian Consulate General, QA Consultants, and XA Hive. We also did a cross-border M&A and tax session with Fasken. And then in June, just recently, just before the launch of the USMCA agreement, we did an interview session with Consul General Zaib Sheikh. And we'll continue to do these webinars as it makes sense for us to you know, continue down a virtual model, and may end up keeping them in place sort of ongoing as a way to complement our live sessions. So the next webinar is going to be an inaugural event for our New York chapter launch. And so that is planned for August 19th at 11 a.m. Pacific time. And we'll have a special guest joining us, the Deputy Consul General of Canada in New York, Kawar Nassim. And so we're pretty thrilled to be able to kick off our New York chapter in a big way with Kawar joining us. So in between these sessions and before we get together live, you can connect with us on social media, on our website, reach out to us directly, that sort of thing. We look forward to staying connected. And we want to thank Knobbe Martens for being a great you know, partner of ours over the years, and for sharing some great content on intellectual property law in the US. So with that, thank you everyone for joining us. And again, as Stephen mentioned, this session will be recorded and we'll make the slides available as well. You'll get an email with details on where to access those. Thank you, everyone. Thanks, Marko, Dan, and Vlad. Appreciate it.
Thank you.